changing lives.
Hello, good evening, cherished viewers, and welcome to the Law Chamber, where legal matters are discussed from a Christian perspective. My name is Anita Delight Dankwa, your hostess for this program, and I will say that season 2 is starting proper today. I'm saying proper because episode 1 and 2 were dealing more of questions and answers from the previous season. This time we are zooming into what we are going to discuss today. Most people think that all they have to do is to work. Work. You wake up around 4, beat the traffic, get to the office, come back around 10, 11, or 6, 7, depending on the kind of work you are doing. And you amass all the wealth you can get. Then at the end of the day, the thinking is, I'm leaving everything to my children. Then you die. And your thinking is that everything is for your children, right? Wrong. So today we are going to discuss how to prepare and be ready for death. What I'm trying to say is that how do you draft and make a will? Frankly speaking, we all hope to know when we are going to die. You know, if God can tell us, Anita, tomorrow we are going to die, prepare. As he did with Hezekiah. You know, Hezekiah was about dying. And God told him, put your house in order. And he did. But at the end of the day, he went back to God and went to negotiate. So the whole idea is that if we knew when we really were going to die, all we had to do is make our wills, put in place the structures to ensure that everything is good. But unfortunately for us, we don't know when we are going to die. We don't know if it's today, it's tomorrow. So why don't you put in place the structures so that, God forbid, should you be no more, your family will not be the ones at risk. So today we are going to discuss how to draft a will, how to make a will, and even if you've not drafted or you've not made your will yet, what should you be thinking about now? Let's say someone has made a will and you're a beneficiary. How do you get those properties in that will? That's what we are going to discuss today. And so just sit back, tell that friend to tell another friend that we are just about beginning the show. It's a live program, so you can send all your questions to 0235 371 287. And we will be discussing and talking about all your questions. So before I even introduce my guest, I know by now you've heard of Pella Fest, right? Oh, Menyasa, you've heard of a Pella Fest. 31st December? Still? Okay, fine. Let me show you the tickets. We are doing Pella Fest, 31st December. If you are single, like some people I know, like Ajopuku, it's 70 Ghana cedis. You see, 70 Ghana cedis. If you are VIP, you see, you don't want to sit with ordinary people. You are the man, 150 Ghana. And some of us, the family, extended family, also, you understand? And you are 5, we are looking at 300 Ghana cedis. So please get your tickets. You can go online and get your ticket, and you can get your ticket by calling the number I just mentioned, and it will be on the screen as well. So please get your ticket. And 31st December, we are doing this with God at the National Theatre. So please, don't forget. And I'll remind you again, you don't worry. The Pella, we are going. Amen. All right, so let me introduce my guest. Let's zoom in. Let me introduce my guest. And we have two very interesting persons with me today. And of course, a male and female. I like balancing things. I have lawyer Frederick Gura Sampson. He's a barrister solicitor with over 7 years of experience. He's done litigation, he's done corporate, he's into both still. One of his specialties is inheritance law. That is what we are discussing today, part of it anyways. And he will let you understand it proper. So I'm not even going to belabor the point. When he starts talking, you understand what I'm talking about. Frederick.
Yes, Anita.
Fred.
Yes, Anita.
Send him a high pill. Hey. Oh, my uncle. I hope you're well.
Well, yes, I'm doing well, and you?
I'm fine. And when you were coming here, it was okay?
Yes, well, it was very okay. I didn't struggle at all.
Okay.
I didn't struggle. So
and then work was good today?
Small.
Few,
yeah.
What's
what they say?
But you don't know.
No, not yet.
You see your life. Oh, this card, I'm no more this card. Then I have lawyer Enesina Oboboche. She's a barrister and solicitor with lots of years of experience. She works with the Cape Coast Office of Legal Aid Commission. She's the assistant legal officer there. Enesina provides legal services to the marginalized in society. Because so legal aid, I know who say, and you remember that since when you mentioned it, if you don't have money, if you're having issues and legal, you go to legal aid. Now we have legal aid officer here. When she's going, she'll leave a number. If you have any issues and you don't have money, that is the office you go to, legal aid. And I'll push her a little bit on it. She's passionate, very passionate about the law. And so she should help us understand why you should make a will. Is it even important? Or maybe you are belaboring the point. So let's zoom in. Welcome.
Thank you very much. Thank you.
So let's zoom in. Let's talk about inheritance law. To the lay person, what is it? What is inheritance law? Enestina.
I think it's basically about the laws that govern how you can get properties from someone who is dead.
Okay.
Basically, yes.
And I hear there are two types. What are they? And
yeah, so you either get properties under a will, or there's no will, and then there will be a law, which is in Ghana, the law 111, which will govern how the properties of the dead person will be shared. Yeah.
So either someone will make a will, or you make a will and give your properties to someone, or you don't make a will. And when you don't make a will, PNDC law 111 will kick in.
Exactly.
So today we are going to talk about when you make a will. So next week we will be talking about when you don't make a will, what will happen. So it will be more of a part 2 like something, but when you don't make a will, what will happen. So who can make a will, and what's the status?
Okay, so well, I mean, essentially, the law is that every person who is 18 years or above may, in writing, make a will, disposing of what belongs to him, or what will belong to him at the time of his death, or what will belong to him at a time after his death. So to answer your question, basically, a person of 18 years or above and of sound mind who has acquired property, personal property, can make a will, disposing of any property that he has to anybody of his choosing.
Okay, so let me try and bring that. So you have to be 18 years.
Yes.
You have to be of sound mind.
Yes.
So if at the time of making the will, I journey touch here, meaning say you can't make a will.
You don't have the capacity to make a will if you are not of a sound mind.
Okay.
Now, the law will actually say that people with insanity may have some lucid moments. So devoid of that. But at the time of executing the will, your mental presence must be intact.
Okay. So 18 years of sound mind. If you are 18 years, you can make a will. Sound mind. I drain it out. You can make a will. And then the properties must be yours. I beg. So those family properties, someone building on family property, family land, and that family cocoa somewhere, and some civil servants will be living in government bungalows, and they will be willing those properties to others. It's a no-no.
Yes. No at all. Even if you use your own money to build the house, so far as it's on family land, you know that you only have the right to live in. But then when you are dead, the family can take the property from you. They can say that, oh, your children can live in up to a point. But then the law is subject to good behavior. And good behavior there. In Ghana, anything can be bad behavior, exactly. And so your children may be coughing at night and someone will come and say, this is bad behavior, so you should leave. And so if you are building and you want to give it out to your children, the best thing is get a land for yourself in your own name. So that will be your private property that you can build to your children.
That's serious.
Yeah.
So it means that, but okay, let me ask this question, because there are other instances where it's family property, but it's been shared. So let's say we are 5 siblings, and this is family land, but we have shared and this is my portion, and I'm building on that portion. Is that allowed?
Yeah, so that becomes your private property then.
Okay.
It's no longer a family property. But then there is a family property that everybody knows that this is a family land. This is this particular family land. So they may even have a family house on it. Then you start building on the side. That when I come on weekends, that's where I'll come and stay. Oh, my children will be here. No, at the time you die, it is there. Everybody knows that this particular land is for this family. You can't argue with them.
So but when you will such a property, what happens?
It means that it's void. Whatever you've done in your will is void. It is no longer yours. It is for your family. And so the children cannot go and fight that just because it's in your will, it is yours. Because the law that says that you can make a will says that you can only make a will on something that is yours. And so if you make a will for government property, we can't give it to your children just because you made the will. So the will does not make that thing yours just because you put it in your will.
That's a strong one. And Fred, let's say, for example, I make a will, and at the end of the day, I want to change. You see, I don't know when I'll die. I'm getting more properties, and that will there. Is it possible to change it? How do I change it? What is it? So maybe I want to wait when I'm about dying, which I don't even know when I'm dying anyway.
The issue is with the uncertainty of the time of death. Like the Bible says that it's appointed unto man once to die. So there is a certainty of death. But the issue is, when will I go? You don't know, I don't know. Of course, I mean, if everybody knew when he was going to die, I will acquire all the properties. If I know that God has given me, let's say, tomorrow and maybe Saturday, then I'll do my will today. So you can do your will today. The law allows you to either do a codicil. Now, a codicil is an addendum to a will that you have already made.
Another big English.
Sorry. So you do a will, then you want to do maybe something as an additional to the will that you have made. So the law allows you to change your will at any time. There is no time limitation. So I could do a will today. Tomorrow I'll acquire a new property. I have the right to change it, or do an entirely new will, or I will do what is called a codicil, just to attach to the main will that I have done. So a person can change his will or do several wills as long as the properties belong to that person and not a family property. Just to add to what has been said, why you can't give a family property in a will is because, I mean, we have a principle in law that says that you can't give what you don't have. If the thing doesn't belong to you, you can't give it out. So that device or disposition that you do in your will, if it is not yours, it will fail. Or the persons who are challenging your right to give that particular property can come and raise a challenge that, look, this property doesn't belong to the testator, so it shouldn't pass under his will. And the court will listen to that person because the property didn't belong to you.
Okay, so who can I will it to? Because it's as if I have to will it to my children. Who do I will it to?
You can will it to anyone at all.
Anyone.
Groups, individuals, church, schools, your
My
children.
alumni.
Yes, your alumni, of course. You can will it is yours. So give it to whoever you want to give it to.
So it means I can make up my mind that this will I'm making, I'm not going to add my children to the will.
So that's one exception under our law.
So ordinarily
you can give it to anybody.
Okay.
But then if you have a child who is less than 18 years, you cannot say I'm excluding that child.
Why not? That child is stubborn.
Unless you have made some provision for that child in his or her lifetime. A child is a child. There are stubborn children everywhere, but the Lord doesn't want to have a lot of children who don't have anybody to take care of. And then the Lord doesn't want people to be willing things to everybody, and then you leave your child to be a responsibility on the society. And so if the child is under 18 years, and you've not made any provision for that child while you're alive, you've not given him any some lump sum bid that he'll be relying on it, then don't say I have taken you out of my will. It is wrong. The child can go to the courts later and say, hey, my father, he did a wrong thing by not giving me anything. He didn't make any provision for me in his lifetime, and now in his old age, he has excluded me. And the court can take something from someone that you gave it to and give it to that child who is under 18, and not just your child. But then if your mother or your father too is alive and you refuse to make any provision, or your spouse is alive and you refuse to make any provision for them in their life, in your lifetime, And then in your will too, they can go to the court and the court can make such orders to take something from someone and give it to them. Although you are dead and gone.
The court will not change your will per se, but the court will give something small out of that property to them.
Yes, they will make a reasonable provision for them. They will look at all the circumstances and say, you know, this woman is this, that, let's give this lump sum, it's okay, or let's give this particular property. And so it may be taken from someone, or maybe something that you didn't give to anyone at all. The court will give it to that person rather.
And there's this should I say, that this general belief that if you are making a will, then it means you are going to die. Okay. And if someone says make a will, it means the person wants you to die, especially the women. Yeah. They'll tell their husband, Charlie, your will, and the husband is like, I don't say me wanna. You understand? Yeah. So it's as if you are making a will, the idea is that you are going to die. What's your take on it?
I think will is planning, and planning is good. I know there's a greeting that says that in Shishe Panera Depe or something. In my church, we say that. And so if you are a king and you are leaving, you want to make sure that you have someone who take over from you. You are planning and training and grooming the person. All the properties, you want to show that person who is supposed to take this and that, so that there will not be fights and chaos in your lineage. The same thing, as family, you have properties, you have people that you want to take care of those properties when you leave. You have responsible people in your family, and the ones that you know that they are more dependent on you, so they should have some special treatment. You have to plan ahead, because if you don't plan, then anybody at all can plan for you without knowing the special circumstances in your family. And so there is no way you should say that someone wants you to die when they say make a will. If God says you won't die right now. But if you would die tomorrow, you would die even if you have a will or you don't have. So let's not.
But sometimes when they realize that you made a will, then they'll kill you, and so that they can take the property.
Okay, so you don't have to let someone see what's in your will.
Okay, so it means it's possible to make a will and no one will even know you've made a will or what is in the will.
Exactly, okay. Unless you go about telling
people that I've made a will.
And if it was prepared by a lawyer, lawyers keep a lot of things confidential. I mean, almost everything with our clients are supposed to keep it confidential. So I'm not going out to say, hey, and Anita came to me to make a will about this. No, not at all. Unless you went to roadside man B that please prepare a will for me and say, hey, this man, he has a lot of things. That's how everybody will get to know that this guy has this and that. And so if you go to the right person to assist you, the person is a professional. He'll keep that intact, or he or she will keep that intact, and nobody will hear about it.
Fred, when can a beneficiary inherit? So I've made a will. When can the people I've given the properties to inherit?
Okay, so I mean, essentially, by law, we construe a will as if the person did it immediately before he died. Okay. So a testator has made a will.
A testator is the person who made the will.
Whoever made the will is a testator.
Okay.
The persons he gifted the properties under his will to are beneficiaries. So when the testator passes, the legal procedure or the practice is that the will be read. Then, when the will is read, you know who are the executors. The executors are persons the testator has put in place to more or less manage his estate, ensure that whatever gift he gave to whoever person gets it. So the executor would apply to the court for what you call a probate. The court would hear the probate application. If everything is regular, the court will grant the probate. You pay the necessary tax. I think it is 3% of the estate value. Then a vesting assent is done by the executor. From then, that is when the beneficiaries will have the legal authority to possibly transfer the properties into their name. But the general position of the law is that, for instance, the executor's power is derived from the will itself. So if you look at Act 63, there is a view that the executor may not necessarily need a probate before he can administer the estate. But the practice is that ideally you go before a court, put the will before the court, let the court confirm that everything is okay, the probate is granted, and then the beneficiaries can also have their entitlement under the will.
So it means that it's only when the testator, the one who made the will, dies, is when the beneficiary can inherit.
Yes.
And so when you die is when the person you've given the property to can inherit. So the notion that if I will the thing to someone, I'll be in the house and the person will come and sack me, doesn't apply. It's only when you die is when the person can take over.
I mean, yes, to the extent that it is a will, the will is not operative until the testator passes.
Until the person who made the will dies.
Yeah, until the person who made the will dies, because that is when it takes effect. Of course, there are other documents or the other processes that if I want to gift a property to my son or my daughter, I would do it whilst I'm alive.
It's a gift.
Those ones are not in the scheme of wills. Those ones are gifts. So I can gift this cap to Anita. It's a gift. Whilst I'm alive, she can have it. But if I say it is in a will, then whilst I'm alive, Anita has no right over that particular property. It is mine and mine alone until God calls me home.
Okay. And Alexia, you want to say something?
Oh no, that's okay.
Okay. So some of the beneficiaries are also of the view that at the end of the day, it's my father's property. So that probate you are talking about, going through that procedure, the minute my father dies, I'm the eldest. So they take control of the property. And we sometimes have situations where family members will come and sack the wife and children from the house, although there is a will.
Yeah.
What happens to these people? Are they trespassing?
I mean, for a lack of a better word, they are trespassing. In law, it's called intermeddling.
Yes.
That's actually a crime under law. You can face up to 2 years.
Yes.
Or penalty, but the penalty
Please
is
explain the intermeddling.
intermeddling. Okay, so intermeddling is the property is there, the person is dead. Instead of you to go to court first before you can administrate or you can execute and give this to whoever is supposed to be given to, you go ahead and do it without going to court. You share it, or you start spending it before even going to court for permission to do so. Immediately you do that, the law says you have broken the law. You are not just breaking the law between you and your father who is dead, but the law of the state, because you are protecting wills. And so you can face up to 2 years in prison.
So those penny people who come to the house and come and sack the woman from the house.
Very wrong.
That person is an intermeddler.
Very wrong.
And when you report that person can be in jail for 2 years.
Yes.
So why is it still happening? Because we hear of stories that they always come in and sack.
Because people don't know their rights under the law.
I think that's why we are here. Yeah.
Exactly.
Yes.
Yes, so I think, so apart from being in prison for a term of years, you may be liable for as twice as the value of the estate you have intermeddled. So
if you sold the car, you'll be made to pay twice of the value of that car.
Well, that is the position of the law. Yeah. That is the extent of your liability.
Now, what if I've chopped the money and I don't have anything? I've chopped the thing.
When the court imposes a fine on you, what happens?
Okay. What happens?
So, well, I mean, it is a fine you have to pay. You may have properties. They will be subject to some execution because the law has imposed a fine. And the law will not think that you have money or not. The law is looking at the offense you have committed. What is the punishment for that offense? So it doesn't matter that I have money or I don't have money. You have committed an offense. You have intermeddled with somebody else's estate. You had no right to do that. Or even if you had a right, at the time you did that, you had no right. So the law will deal with you as you are supposed to.
And so some of the family members too, the children, they go like, okay, we have 4 children, we have 4 houses. You pick one, you pick one, you pick one, you pick one. It's all wrong.
Is it in a will or?
No, the will is there, but they've not gone from it. They've not done anything. They are sharing.
You see, it is wrong in the sense that you don't know what is in the will.
Yes.
You understand? Like she said, there is what we call testamentary freedom. A person is entitled to give.
So it's possible that those 4 houses, he didn't give to any of the children.
Yeah.
So the fact that your father doesn't mean any of my houses belong to you. I may have given it to any other person because of maybe something that you have done to me whilst I was alive. So until the will is read, you have no business sharing the property because you don't know what is there.
And I had a client, and it's so funny. This client, and still he's alive actually. Sometimes he'll call you and goes like, Anita, I want to change my will. Then I go like, boss, say last 2 weeks we now changing will. Say me baba akwa hear me biom. Person me in the film. So every time he takes one of the children out, so far as you offend him, he takes you out of the will. And I'm like, fine, he makes the work difficult for me, but that is it. You can always change your mind. And I wanted to say something.
Yes, I wanted to say that aside from being wrong and the fact that it may not have been willed to you, you will need what is called vesting assent to know that this is your property. Because if your father gives something to you in a will, maybe say a building, and tomorrow you want to go and sell it, but you didn't go to court for permission to sell it, if you're coming to sell it to me or my client, I'll ask you, what shows that you have this? You can go and bring your father's documents. If I see your father's document, your father is dead and gone. So there should be some authority that says that now it is yours. And that is why we go to courts. When the executors go to courts, then they have the permission to prepare the vesting assent. That is also a document like a title, and give it to you that, you know, Anita, this is yours. We have given it to you. From now on, you can do it will be in your name. Whatever it is, you can do with it. And so let's just make sure the right thing is done, because sometimes in the long run they go to court and say, this is my property, my father willed it to me. And I was like, what shows? 10 years ago when they willed it to you, didn't do the right thing by going to court and getting a vesting assent. So now it's too late. Now you can't claim it is yours. And if I'm a lawyer on the other side, I will say, this is not yours. You're lying to the court.
Exactly.
And so you have to go through the right process. As somebody and buyer, you would think it is normal.
You are living in your father's house.
Exactly. Until one day you want to sack a tenant and say, what's your power?
You're not the one who...
Your father is dead.
Your father was the landlord. You are not the landlord.
Exactly.
And then you say, what is that? What document shows that it's yours?
Exactly.
Then
So do the right thing. If you do it right, you won't have issues later. And that's it about the law that people don't know. So people are in the courts because they didn't know their rights and their laws earlier. And so now that we are learning, make sure you do the right thing, get the vesting assent, and then you'll be sorted.
Okay. So I had a couple come to me and they wanted to make their will. And the man doesn't want to make it. The woman doesn't want to make it. Of course. The idea is that I don't want to die, and the idea is that, no, you should will it to me. And the funny thing, actually, let me say this in part. The funny thing is that when the men are willing, they will to the woman and the children. When the women are willing, they will it to the children only. And I go like, hey, how is it happening? Please, we're also making money. So please, remember your husbands when you're willing. Is it advisable for a couple to, is it possible and advisable for a couple to do their will together?
Well, is it possible? Yes. I've seen a couple do their will together. What happened is that, of course, they both gave every property to their only son. So it is possible. I think it's a little bit complicated when, let's say, you have other children and there is no agreement as to who takes what or which property is each of us giving. So that, I mean, because the Constitution guarantees your right to acquire property, you are married, you may have your own property. Your husband may also have his own property. You can decide, I mean, unless you have an agreement that, look, this house belongs to both of us. We are giving it to our 4 children.
Equally.
That one, there is no problem. You can do it. Nothing prevents you from doing one will as a couple.
So when you do that, then will both parents have to die before the will come into effect? Or when one dies, the will come into effect? What happens?
Yes, when one dies, the part that affects that person comes into effect, and then it starts working. Then when the other person dies, the other one too also comes into effect. And so until both of them die, it doesn't mean that the first person's death will wait. No, even if it has to be 20 years, no. And so it also means that you have to wait till the first person dies before that part comes into effect.
Okay.
Because it's possible for them to will something which is personal to them, to someone, and then the other person would also will something which is personal to them in the same will. Yeah, exactly.
Can I draft a will by myself? Can I sit in my bedroom and, I know my properties. So these are my properties. So, and we have, in the past, we had Samanso, right?
Yeah.
The older people, they write Samanso, they write, this one goes to this person, this one goes to that person, this one goes to that. And that is my will. Is that allowed? And is it advisable?
You can do it. There's nothing that you can't do. You can do it. Is it allowed? Yes, it is allowed. You can make your own will. Is it advisable? It is not advisable. Samanso was oral because our customary law knows oral. And so you can call just 2 people and say, oh, from now I'm giving this to this when I die, and then that is sorted. There'll be witnesses there. But when you are writing in somebody's language, you may be fluent in English or whatever language you're writing in, but law is quite technical. Although it is your properties, the interpretation that can be put to something that you wrote can mean a lot of things. It can lead to a lot of litigation when you die. Your best shot is to go and see a lawyer and say, lawyer,
you want George to do?
Not that we want George to do. Even if you don't do it the right way, we'll get a lot of job.
Actually, that's true. So if you don't make a will, we have get more money than when you make a will.
Because when you make a will, it's one time. We do it proper for you, go and seal it and put it there. But if you don't make a will, it means, or you make it on your own, it means the English somewhere will be trying to interpret it for like 2 years or 3 years in court. I'll be taking a lot of transport and all from you.
By the time you are done, the property is finished.
Not just that, and your family members too will be fighting among themselves.
Yes.
And so just get the money, go see a lawyer. Let them do it the right way for you. If not, one day, we will now your children may be fighting among themselves just because of a word which is maybe is or was. And
people have the misconception that my family, they are peaceful. They will not fight over properties. And I go like, you have no idea. Sadly. When it comes to properties, people change. When it comes to money, people change.
Yes.
So the person comes to you as a lawyer. Fred, with your quota, with your air-conditioned office, how much are you charging the person for making a will?
I think the scale of fees.
What is scale of fees?
So the scale of fees is more or less a guide by which lawyers charge their clients.
So it means lawyers we have?
Yes. So you can have recourse to the scale of fees. And the scale of fees, which was currently reviewed in 2022, talks about a maximum amount of 6,000 cedis for a simple will.
Simple will?
Yes.
Or
that's simple will.
Yes.
6,000 for simple will.
If it is a complicated will, 18,000 cedis. You can also charge hourly rates if it is beyond that. So that's
a lot of money. And so what happens, because I've heard of some lawyers taking percentage of the whole property.
Well, I mean, it is also done. I've seen it being done in practice. So, I mean, to the extent that it is not outside the law, because again, it is an agreement that you have to do. The scale of fees is a guide. It guides you. But you are also entitled to have an agreement with your client. So if I say, okay, do this will for me, I'll pay 1% fee of the estate. The estate may be huge.
Yeah.
If the client agrees to pay that amount of money. But the scale of fees is a guide to guide all of us in our dealings with clients.
So take me through the steps. I come to your office. I want to make a will. What do you need? And what will you do? And at the end of the day, how do I get the will done?
Okay, so essentially, when you come to a lawyer's office that you want to do a will, the first thing one would want to confirm is, okay, let me have the list of properties that you own. Because, again, you can't give what you don't have. So the list of properties that belong to you. You also have to tell the lawyer who are your executors, the people that you trust, that you want to leave everything for them, so that in the event of your passing,
they will be sharing the
things. They will share the properties in accordance with your will. And they must be people of trust, people that you trust, not any other person who you think, this person, I can't trust him. I mean, if you can't trust a person and you make him an executor, you are putting your estate in jeopardy.
Some of them collude with some of the family members,
yes.
And they will rather take the properties and not give it to the beneficiaries,
exactly.
Especially when the beneficiaries are underage.
Exactly.
Yeah.
Then you also need to tell the lawyer who you are giving what. Then you would get the persons who would attest for you.
What does that mean?
Witnesses.
Okay.
Because
how many do you need?
The law, minimum of 2. The law is that a will is not valid unless it is executed by the testator and at least 2 other witnesses. The witnesses need not see the contents of the will. So when the 2 witnesses, when it is signed by the testator and attested to by the 2 witnesses, the will is done.
Okay.
You understand? Then the lawyer would have to, ideally, if you look at the Wills Act in Section 11, it provides for depositing the will in the court for safe custody. Mm-hmm. So ideally, the will is done, you seal it, you deposit a copy in the registry of the court. You, the lawyer, can keep 1. Then you give 1 or 2 to the client or the testator.
So generally, we will be looking at 3 copies. The court will have 1.
Yes.
The lawyer will have 1, and then the one making the will will have 1.
Yes.
Okay.
Yes.
So that when something happens,
exactly,
they step in.
Yes.
Okay. So, maminka o tree mu. Let me summarize this in tree. Okay. So, ade yaka so far na say, ubetimi aye wankasa will. Benya advice was so wankasa will ye den. Will ye say, o try aka say, me japade we me dema we. Adwene say, unim da obewu. Nti unim da obewu na adna won hye nyama ntoto ho na wonka say, se me fimu a me pese me japade we ko we ho. Japade na e che say ye wawo de. Japade enye wo de no ntimi fa ma obi. Nti sa ebusua asase no wakosi dan wo so. Uwi a wo say ye wo de enye wo de. Nipa na asase ne ye ne de no. Ono na bibia wo asase ne so ye ne de. Nti ebusua asase a ye nche ye mfa wo de ma wo ye. Na wakoyi koko wo so wakosi dan wo so. Ntimi emfa ma wo mba enye wo mba de ebusua fo de. Edu baby so obi wo hono ma otena oye ne aban na ye djuma aban ama ne dan na akotena dan ni mu afei obewu oye ne will a na afei o de ahye will nim say sa dan na otimu no o de ma ne nkola ade ne nya o de a untimi wele ba say o de atimi wele ma obi a opa umba crown fa mom opa o de be ma sorry opa o de be ma school nipa person de ma ne bia obetimi de aprochi kra no ebi de mom nkraman bagana how de makrame be ku krama na we me finance ba ade a me pese me China so betimi de property na mo obi ye a ope oni obi aware a mutimi ye bom aware fo mi no mutimi ka muti bom say e japade we ni e de ma we say obi aso person no kwan ne de ne so a e allowed most of na not mo say be ma ne mema bebre no mo ba me ho no mo ye ma mo yere ne mo mba e ma ne ba no ma ya mo mma pe so na akunu so mi kunu betimi ahwe ne ho because oba no mpese oba afoforo bewu na oba afoforo be ware ne kunu na oba afoforo be di ne jabade ma yen kwa ne sa but all things being equal no
planet
you see aye ni aye bi kakra na why will ewie no ai wadwimu no why say my will watch what they at them say why will sa ade na watch no ebetimi dimu ebie so ntimi ndimu nti advice say obehu lawyer scan bi wom kakra paso wanye will wanye sanya mani ni na at the end of the day no ofimu a oje say me o say den me nkola ne de omo nku omo pem ho asem do mo ho ma da ebe japade a na hu say nipa nse da endom ho sa nti ade na je so ma san tokwa ne ba ebusuanim abra obetimi ama ebusuane dimu Hezekiah ba bewu no nyakopo ka bibi twen no o se tutu fie yie ansa wewu nti ask Christo ni no wututu fie yie ana request a person say no me yanko for this short commercial break. We'll be right back.
For one night only, the city will converge at the National Theatre as United in Praise presents the A Cappella Festival. Yes! Brace for a divine musical experience on Saturday, December 31, as Ghana's hottest a cappella groups usher us into 2023 in a grand style. On stage performing Black Cappella, The Manifest, Vocal Path, Note 6, K3M, New Era, Soul Street, and many more. Special appearances by Pesdak Praise Choir, Gifted Dear, Mark Enimirenchi, and Perez Music. Get an early bird tickets now at a cool 70 Ghana Cedis standard for single, 150 Ghana Cedis VIP, and 300 Ghana Cedis for a family of 5. Simply dial *928 *529 hash to get your tickets now. The A Cappella Festival is proudly endorsed by Beyond the Return and supported by Charterhouse, Events Dome, Midima Fuheba Clinic, Meridian Ghana Conference, and powered by United in Praise. Pella Fest, a Hope Channel Ghana production.
Welcome back. We've been discussing wills, right? So now let's try to compare wills with Samansil. Samansil, most often than not, is the traditional kind of making a will orally. You understand? So now we are so in a traditional setting, in a Ghanaian traditional setting, we call it Samansil. You opening your mouth to tell people that these are the people I want to give my properties to. And then the traditional thing is done, and the people come officially to you and say that thank you for the gift, or thank you for, so that when you die, those people will take it. So, Ernestina, let me ask, the difference between a will and Samansil, and is it advisable? Do people still do Samansil, and is it advisable?
Yeah, people still do, because people don't know how to write, and they may not have lawyers around them.
And when they don't have money, 6,000, it's quite, that's the least though, exactly. 6,000 least.
No, maximum.
That's a simple will.
Simple will.
Simple. So if it's medium, moderate, complex, you're going up.
Yes, now you're going. If there's, even if someone on the roadside wants to do it for you, that one too is expensive. And it's even more expensive because it may lead to litigation when you are gone. And so people still call their family members and say, oh, when I die, you know, this car was for this person, that. So people still do in Samansil. And our law does not take away in Samansil from us.
So the law recognizes that we have a Samansil.
Exactly. Okay. And so if you do in Samansil, just as it is done, usually there should be at least one witness. Some law says that one witness. Because Samansil is customary, the law is sometimes fluctuating in other areas. So some says that 2. But at least get 2 witnesses, it won't be bad. Some say if it's possible, let a family member be there. But I mean, because we don't live close to our families these days, you can still have 2 people there who are not your family members and can still make a valid Samansil, and it will work perfectly like a will. We just have to get those 2 people to come and say this will was made. But that's a problem, because how sure are you that those people will outlive you? It's possible that the witnesses that you called may die on their way back. And maybe you also die the next moment. Then who are we going to ask? So that's the issue with not writing the will. And if you are writing it on your own, you may think that is Samansil, because that shows that you're actually doing a will properly, so-called, which is the will that has to be written down. And so if you are writing it down, then it has to comply with all the laws that you may not even know. And so, go ahead and get 2 people to come and stand there and say all that you want to say. But if you want to write it down, make sure you have the right person with the proper knowledge in the law to guide you to know who should sign, how the signature should come in, because those are technical things that may come up later in life.
So I came across a case, Fred, where so we have SNET benefits, right? And it's your property, it's yours. But under SNET, you have beneficiaries there. That if I should be no more, these are the people I want to benefit. And then in the will, the person makes mention of the SNET benefits, and then the tier 2 and tier 3 benefits, and then mentions other group of people. What happens?
Well, I think so. What happens with wills and SNET? At all times, the nominations as SNET will always prevail. So when a person passes and even want to access the entitlement at SNET, SNET may not necessarily even ask you to either go for an early or a probate. What SNET will need to confirm is, okay, this is my name. The person we are dealing with is my father. He has passed. So the nominations at SNET would always prevail. When there is a conflict, of course, what is in the will would have to be subdued by what you have nominated whoever to get at SNET.
Okay, so what I'm saying is that SNET tier 2, tier 3, depending on the beneficiaries there will take.
Yes.
So it's better it's better not to put it in your will.
Exactly.
And if you want to change it, just go to SNET. And we'll have a topic where we'll be inviting SNET here. Go to SNET. It takes less than 30 minutes to pick their form and change your beneficiaries. Because sometimes you're not married. So it's your brother and your sister who you've put there. You understand? And so when you are no more, they are the ones going to benefit. Unless one of your children under the age of 18, and then that person even gets 60% or something. Like, so there it's your brother and your sister. In the will you've written it, you're giving it to your children. Your children will not get it. So if you want to really change something in your SNIT benefit, please, you walk to the SNIT office. They'll give you a form. It takes even less than 10 minutes to fill that thing out, and you'll be done. So don't make that mistake of putting your beneficiaries in. So, and Esina, what are some of the misconceptions when it comes to making of wills?
I think we have already mentioned some of them, that when you do, it means you are just about to die. That's why you are doing it. And we know that it's not the truth. And then we also know that you can sit in your house and do it. Of course, that is not the truth based on what we've said. And then you say that it's only when you have money or you have a lot of property.
Yes. Someone say, I'm 18 years, I don't have anything.
Hey, you have a shoe.
Are you? They are going to fight over my shoe.
You don't know. Somebody is eyeing that shoe.
Whoa.
Exactly. And then your phone, iPhone, anything at all, your suits. Maybe in your family, you are the only one who has a suit. Before you die, somebody is saying, Kweku's suit is mine. Exactly. So anything at all can be
So
will.
you don't need to have lots of money.
No.
Just
1,000 cedis, 100 cedis in a bank account is a lot of money that one of your family members may be eyeing, and they may fight about it, and then they may fight on it. And if you don't do it, the option, it may be scary, maybe percentages and ratios. Next week, when you do it, you will know that the options there or the alternative is scary. So you are better off if you do the will, and then you put every pin that you have in the will, so that anybody that you want to give it to, and then if you do a will too, you can give it to churches and charity.
Especially our church,
you know, yes.
That we are building that we never finish building. So if you are dying and you put it in your will that SDA, your church, you are giving us 20,000. It can roof our church building. So when you are willing, please don't forget the SDA church. Okay, don't forget the church. You are not Adventist, right?
Yes, I am. So I'm fighting for a church.
You're already fighting for the
Yes.
That's Cape Coast and Praise Emmanuel.
No, I'm now Pedu.
You are now Pedu.
Yes.
Still Cape Coast.
Yes.
Oh, okay.
Yes.
Okay. And
I'm a Methodist.
Methodist for the Mosca. Yeah, well, yeah, what are some of the misconceptions?
Well, I think she has said, she said almost all of them. Possibly just to reiterate that you don't need to wait to amass all the wealth before, because, you may never know when you are going to go. So if you wait and you are unable to do it, then a law is going to determine who gets what. Maybe you didn't want a particular person to get something under your estate, but because you didn't do the will, the person may have. And then also the issue about the cost. I think even though, as I mentioned, there is a scale of fee, but I think most people also have this perception that will is expensive. Doing will is expensive. I think, as I said, the scale of fee is a guide. There are instances where people engage lawyers and they are able to negotiate a reasonable fee. So don't look at the costs involved in engaging a lawyer and say that, though, as for me, because the will is too expensive, I would not want to do something. That is also some misconception that one could think about.
So I have a question here, and the question is talking about Samanso. Okay. So the person is asking, is it possible to have a video done? We are in the tech world now, you see. So we are doing, I'm saying it, and I video everything. Okay. Is that allowed, and is it?
I think to a point, our customary law is oral, but then the law changes and it's willing to adapt itself to reasonable changes. And so if you have an oral recording of yourself and then there are witnesses, or a video recording of yourself and there are witnesses, it may look new, but that's something that if I were a judge, I would consider that is a very good way of making a will so that there will be no challenge later in life.
If I were a lawyer a judge too, I would have considered it.
Yes.
If you were a judge, will you consider it?
I think, to the extent that law evolves, so I will consider it, because at the end of the day, what makes Samanso so? It is because it is oral. Mm-hmm. And like she said, when you are doing in Samanso, there is always the issue of when you get a witness at the time of your passing, if the witnesses predecease you, how do you prove that this was a hand? So that if I'm able to get it recorded and put it somewhere. If I were a judge, I think I would also
consider it. Okay,
consider
so
it.
Joe Frank is saying, we are learning tonight. Thank you, Joe. And then Robert Suma is saying, for Christians, executing a will is a mark of a good steward. It enables us to account to God in respect of blessings bestowed on us during our lifetime. By executing a will, you are able to give your property to a responsible person or institution for the benefit of humanity and God. Leaving your property without a will is reckless and a mark of unprofitable servant. Adventists are admonished, or elder, Adventists are admonished to list names of relations in their wills merely because they are relatives, if they are well-to-do and are not in need. So Adventists are admonished not to list names of relations in their wills merely because they are relatives, if they are well-to-do and are not in need. Nana Anzi say, thanks for the clarity between the summons sale and the will. Okay. Yes, that was a yes.
Talking about costs.
Yes.
Since I'm from legal aid, let me
I was actually going to push
I know you come here. Let me tell my people that we know that a lot of people may not have the means to pay 6,000, but maybe you may have a house or you may have something which is worth less than 6,000 cedis, and so you don't have to go and pay 6,000 to a lawyer to will something which is less than 6,000. Government, by magnanimously, they have given us legal aid commission that you can just walk in, there will be a lawyer there, you tell the lawyer that this is what I want to do, but I do not have the means to do it, and so please assist me. And we draft wills for people for free in Ghana, and thankfully we have all the 10 regions.
You are spoiling our work. Really?
No, I'm not spoiling because we have criteria.
Spoiling in quotes.
No.
Okay,
we have criteria. So if you come and you have money, obviously if you have 10 houses or 3 houses, you should be able to get money to will your house. But then if you have just a single room somewhere in a village somewhere, which the worth is not more than maybe 5,000 or 6,000, I would not expect that you go and pay 6,000 to a private lawyer. I'll be kind enough to say
just 6,000, they budget 2,000.
2,000, and then could you see now I know how for cry with that. I am just saying, just because I represent them, I'm saying this for people who may want to make a will for things which may not be worth more than the price that a private lawyer may charge. If you go into any of our offices nationwide, they may assist you and prepare the will for you for free. Maybe what you have to pay is the filing fees at the courts. Yeah. Because when you are going to file and the court will have to stamp it for you, they'll take some money, and that will be less than, I think, 200, depending on where you are taking the money to. Maybe our senior can guide us on how much the court may take, but that will not be up to 500.
No.
Not at all. So if you want services of a legal aid officer, you may do that. But I'm not spoiling the market for our private lawyers, of course.
It's very important.
They have their clients. They always get
that.
Yeah, we also have our special clients.
So we have a question. Good evening, attorneys. I'm enjoying the program. Please, I want to find out if a man dies intestate. That's for next week. Intestacy. We are doing this next week. But I'll let them touch on it because you sent it. A man dies intestate. Intestate means a person has died without making a will. And that's the topic for next week. And his properties are collected from his wife and children by his extended family. Can those properties be still reclaimed by the wife and children after some years?
I think so. For me, yes. The law is so clear on what happens when a person dies intestate. And because you are going to discuss it next week, I'll just be very brief. No extended family member is entitled to go and take any property away from the surviving spouse and children. The law is clear. You get what you are entitled to under the law. So there is no point in running ahead of yourself. The law provides what the surviving spouse and the children should get, what the parents, if they are alive, should get, what goes to the family. So it is very wrong for any extended family member to purport to go and take what doesn't belong to.
So next week we'll be delving into intestacy. But please, at the end of your statement, you said some years. Don't wait for some years. Exactly. Because if you wait and they've already chopped the money and there's nothing to trace and nothing, you lose out. Because we tell them to bring it and there's nothing to bring. You understand? Exactly. So please, the minutes, don't let them drive you out of the house. Legal aid is there. Yeah. You see, legal aid, all things, it's free. She's seated there. You are take a number for you. It's free. If you don't, that's if you don't have money. It's free, and they will do all the work for you for free.
Okay.
You see, it saddens me because most often than not, you see people driving the women out of their house, driving the children out of their house over properties their parents have made.
Yeah.
It's a no-no. But it's still happening in Ghana. So please don't let it happen to you. Let's educate us. So your final words. Let me start with Ernestina. Your final words.
Now you know the right thing. Just do the right thing. Plan ahead. That is what God wants you to do. He doesn't want you to leave things in anybody's hands. Someone who hasn't suffered before to come and determine how your property should be shared. So please do the right thing so that you can secure your future when you are not there. The future of your children, the future of your church, the future of an organization like Legal Aid Commission. You can will something to us. Anything you can do to help.
Is that okay? You go.
It's all campaigning. You know? So anything, if you want to do something right, you have to take the steps to do it.
Yeah.
Don't wait till you are dead. And then you can go to any of the places, the right places for professionals to do it for you. You don't have to tell the whole world that you've made a will. And if you tell a lawyer, you've told the lawyer only. And so please go to the right people to assist you.
And when the lawyer dies, before you die?
There's an office. Your will be there. It will be in the courtroom.
In the courts
exactly.
itself.
Nobody.
So sometimes you are not sure if your mother or father made a will. So you go to court and go and ask the court if you search. So ask the court, did my mother or father made a will? That's if you suspect. So the court will officially respond to you and tell you, yes, your mother made a will. And if you need a court, it's simple. Why? All right. So Fred, your final words.
Well, so essentially, I think it is very important to do a will. There are several advantages, as we have discussed. You get the opportunity to determine who gets what. You also help your family to avoid unnecessary litigation, etc. So I would encourage all of us to, as much as possible, try to plan ahead, do your will. Don't think of waiting to amass all the wealth before it is done. Do it. There's opportunity for you to change or add on or even take something out at any time so that there will be certainty. I mean, once it is done, it is settled that, look, this property goes to this my son, this property goes to this my son. And I think it is a sign of blessing.
Amen.
Amen.
1 Timothy 5:8 says something very interesting. It says, if any provide not for his own, and especially for those of his own house, he hath denied the faith and is worse than an infidel. And when you get to, and there's another one I love here, which talks about the fact that you are supposed to make a will. It says that John 19:23 says, when Jesus saw therefore his mother and the disciples standing by whom he loved, he said unto his mother, woman, behold thy son. So before God died, Christ died, he realized that the mother would need support. And so gave the, and Hezekiah, we've already talked about Hezekiah. And in the Bible, when we talk about line of succession, the first son usually is the one who takes the blessing. And so the person is the one who will take over the property. So now we don't have something like that. That is the first child who will take over. What are you doing? What is the plan? Should you die tomorrow? Have you made adequate preparation for someone to take over? For someone to take over your properties, your shares in the companies, your company itself, the houses, the lands, the car, the shoe. You've not done anything. Benjamin Franklin is telling you, if you fail to plan, you are planning to fail. So if you work all day, you toil, do all this work, and you are not planning, and you die, and all that wealth you've made, what happens? What happens? You there, don't make your will. Me there, 31st, we are going. Right? So, Pella first. 70 Ghana cedis. If you are single, 31st December, please don't forget, 31st December is booked. We are doing this on the 31st of December. We are going to praise God. We are going to sing, listen to good music. We are going to enjoy ourselves as we enter into the new year. If you are so many like my family, five family of 5, it's just 300 Ghana cedis. And if you are VIP, we are not going to sit back and then we'll not see the things well. We want to sit in front, strategic place. It's 150 Ghana cedis. Don't forget to get your tickets now. The numbers down your screen, you can call, and it's going to be at the National Theatre. Air conditioning, so please, don't forget to get your ticket. And if you call us, we'll bring it to you. Courier service, of course, at a cost. So, make up your mind. Start putting on paper your properties and who is going to inherit. And by God's grace, we'll live long and get to the 70. But God forbid, if you don't get there, you've already made the plans. And our children will not suffer. Stay safe, save blessed. Until next week, where we'll talk about inheritance, when you don't make a will, what will happen? Stay blessed.